Hey guys, we're getting close to the end. We've only got a couple of chapters left to go. In a couple of weeks, you'll be done. For some of you, this is the first time doing something online. Clearly, it's kind of the first time for me to be doing it. But we're getting through it. The thing to understand is we've got a lot going on right now in criminal justice. Clearly out there, lots of protests, lots of things happening. I wish I could have a lengthy discussion with most of you, because we get so focused on things that the police are doing in criminal justice that we need to change, which we do, but we forget the other two components, corrections and the courts. And we're going to talk about the courts briefly. I put that video on earlier because I want you to get an idea of this is how we teach lawyers in law school first year about this understanding of federalism, because that's critical to understand. So when you watch her video, she's very good at explaining to you, this is what the federal government does, this is the Constitution, this is what state governments do. And look at what's happening today. Just look at Oregon. We've got federal police officers in Oregon, not because Oregon wants them there. In fact, the mayor of Oregon doesn't want them there at all. Today, the mayor of Oregon was tear gassed because the mayor was there trying to stop him. So we're watching federal agents now come in to a town and exert that influence. And I would love to have a lovely debate about that. Clearly, when we saw a couple of years ago when the Bundy rebellion was going on, that was their whole premise, that federal agents should not be allowed to do things. At that time, it was about cows and about being told that they have the right to bear arms. We have something very similar here. This is the right to protest, peaceful assembly. And we actually have federal agents there with guns. Yesterday we could see they were using batons on people. And what's interesting is we don't see a lot of the Bundy supporters that were in fear of this federal intrusion that are showing up in support of this First Amendment right. You would expect them to be there saying, why do we have federal officers here? They shouldn't be here. And more importantly, we have generals in our military saying, why are these federal officers wearing camouflage like our military? Do we really want to live in a country where the military can come in and act like police? So it's just something I want you to be thinking about when we get to the courts and we get to corrections, and as we start to look at this federalism. So let's talk briefly about the courts. I'm not going to go into a high school discussion. I want you to read that chapter on courts and have an understanding of what happens in our courts. Most of you do have that understanding. I'm going to briefly hit on a couple of things because we do have international students. We have students that don't really understand our system. So I'm going to touch on things. Some of these things, clearly, you're going to be tested on. Things that I have to. It has to be on your final. I'll let you know at that point. Know this. For instance, plea bargains. Plea bargains is kind of unique to the U.S. system of justice. This idea of a plea is not unique worldwide when someone has to formally answer the question, are you guilty or are you not guilty? But what's unique to us is this plea bargain that we do in the United States, which is nothing more than negotiations. It's where the prosecutor gets with the public defender and they negotiate some kind of punishment. And this idea of almost like a car buying, when you're buying a car, you're negotiating. You don't see that a lot in other parts of the world. Clearly, what I want you to understand as we go into this debate, that in all three areas of criminal justice, the police, corrections, and the courts, the most powerful person in this game, if this was a board game like Monopoly, the most powerful person is the prosecutor. It's not the cops. It's not the judge. The cops can make an arrest, but the prosecutor decides whether we continue to play the game. The judge is not powerful unless the game has been played by the prosecutor. The judge cannot force a prosecutor to bring a case. The cops cannot force a prosecutor to bring a case. A prosecutor is powerful because they decide whether or not someone is even going to be prosecuted. So understand, there's a lot of power in that position, way beyond what the cops do and what the judges do. So again, we've said a couple of terms that I haven't defined. Prosecutor in the United States is that person that is going to take the probable cause that the law enforcement officer has and proceed into the courts. Remember, we talked in previous discussions. The way they proceed is through an indictment. An indictment has to come into play either through a grand jury or through a preliminary hearing. If the judge at that point believes there's enough probable cause, we move forward to a real trial. At that point, the trial will happen unless a plea bargain exists. So remember, it's extremely important to understand the prosecutor is the powerful person here. The judge in our system is nothing more than a referee. When you go around the world, when I've had students in Paris and in London, and whether we're in Ireland, when they see judges in their criminal courts that are active participants, that's a different system. Our judge does not get involved in the process. They just make sure the process is being done right. So remember, keep in mind that the judge is not an active participant. The judge in most jurisdictions, based on the population, has gone to law school. So they do have this law credential. But there are small towns across the country. Many of you might have came from a small town where we call it a justice of the peace. A justice of the peace does not have to have a degree in law. If you have a small population, small town, it's the same job, but it will be performed what we call a justice of the peace, both of which, the judge and the justice of the peace, will be elected by the people. But keep in mind, when we say justice of the peace, generally that means they don't have to have a law degree. And when we start talking about the other side of the table, it's the defense counsel. We clearly in this country have a constitution, and you have the right to have an attorney. How many times have you heard on the TV? If you can't afford one, we will provide one for you. So we have this whole system where we have a prosecutor and where we have this court-appointed public defender that will come in and represent the person that we have arrested. This system that we have, and remember this, you're going to need to know this, is called an adversarial system. We have an adversarial system in our country. That's what we want. We want the prosecutor to argue with the defense counsel. We believe that through arguing in this adversarial system, with the judge being the referee, that we will get to the truth. In other countries, Canada, in Europe, in places in Germany, in all over France, and in London, they don't have that system. They believe they can get to the truth. The judge is an active participant. The defense and the prosecutor work together to come to a common decision on whether somebody did something. We don't do that. This class is not meant to have this as an opinion. I'm just teaching you this is what we have. If you go into law school, you're going to learn in depth about our adversarial system. So keep that in mind. It's intended to be that arguing back and forth. A couple of other things. Normally if you're in class, we would talk about, a lot of you here think that it's not ethical that we give somebody a public defender. For instance, we have this individual that killed these 3 guys that went out fishing in Florida. A lot of you are saying, why do we have to give them a public defender? And is it ethical to do that? When a public defender, if you're that attorney, how can you defend somebody that you know just killed somebody? Remember, just like to many people in the United States, how important it is to have their Second Amendment to carry a gun, or your First Amendment to be able to protest, we have in our Constitution, you have the right to have counsel and to make sure that everything that is done to you, from the time that you're arrested to the time that you're punished, that we play the game right. This is not about saying it's okay to kill people, but we're going to make sure that you have an attorney to protect your rights. It's protecting your rights per the Constitution, to make sure the game is played as you go through this system. So yes, it is ethical. They need to have someone to advise them throughout. So keep that in mind. As we talk about the court system and as we talk about testifying, because when it does go to a jury, and here's something I want you to know because you'll see it on a test. In this country, 85% of our cases are a result of a plea bargain. We don't go to trial very often in this country. That should tell you something. Most of the time we come to a negotiation based on, rather than go to trial, will you accept this plea? 85% of the time. In my 25 years in law enforcement, I probably only testified in front of a jury about a dozen times. It just doesn't happen that much. However, when it does, we sequester a jury. I'm not going to get a lot into that. Read through your chapter. How do we get a jury? But when we put witnesses on the stand, this is critical because I get a lot of students that don't understand what's going on. The only people that can get on into the stand and testify when something happened criminally are those witnesses that we call a lay witness, L-A-Y. A lay witness is somebody, we're not expecting an opinion from you. We don't care about your opinion. You're testifying about something that you absolutely experienced, something you saw, something you heard, something that you were involved in, you. We don't allow you to testify to anything that you didn't experience. We call that hearsay. Know that. Hearsay means if you get on the stand and you say, well, I know this because my brother told me, we're not going to allow that in our trial. It's going to be excluded from evidence. We do not allow hearsay from a lay witness. We do not allow an opinion, only what you have experienced. However, the second type of witness is called an expert witness. And I've had to testify on the stand as an expert witness, for instance, with drugs. I'm a drug recognition expert. So in order to testify, and the key to this is, the only time you can give your opinion on the stand is if you are declared an expert by the judge. Remember, the judge is the referee. So the attorneys will put you up on the stand, whether you're an expert for the defense or for the prosecutor. They will lay a foundation explaining why they believe you're an expert. And as they start to say all the training, all the schooling, all the things you've been through, you are definitely an expert in this field, whether it's a doctor, whether it's a psychiatrist, whether it's a drug recognition expert. If the judge agrees, yes, you meet the qualifications, you can then be expected to be an expert witness. You can now give your opinion. Otherwise, you cannot testify about your opinion. Another thing, and this comes up and it's highly debated, and a lot of times people don't understand what they're really saying, which is perjury. What is perjury and what does it mean? Perjury is not just about lying, okay? If you're on the stand as a witness and you're giving testimony to something that you thought you saw, thought you heard, but you're wrong. Think about it. You're absolutely wrong. Your eyes were lying to you. Many times we wrongly convict people because the victim thought that this was the suspect. They picked him out of a lineup saying, yes, that person did it. They thought that was the person, but they're wrong. So you can be wrong and give testimony on the stand that is clearly not accurate, not truthful, but if you believe it to be truthful, it is not perjury. Perjury is when you're on the stand and you know damn well that what you're saying is a lie. You know it's not true. You know it's not accurate, but you're still saying it on the stand. That is perjury. That is criminal, and we can prosecute you for perjury. So understand the difference, okay? A couple of other things. Two types of evidence that are presented in court. Direct evidence. Direct evidence is when we have something that's very strong, kind of like video, someone's got you on cell phone, pretty strong evidence. We've got eyewitness testimony. So direct evidence is pretty strong. It's difficult to say it didn't happen because we've got this direct, strong evidence. That's different than what we call indirect evidence, or what you hear on TV all the time as circumstantial evidence. Circumstantial evidence is not certain. We're not certain that it happened, but we've got a pretty good idea. If your fingerprints are on the gun, you probably did this. So again, circumstantial evidence is what we use in courts most of the time, meaning, no, we're not certain, but we're pretty certain based on how much evidence that we have. And that circumstantial evidence, we're trying to draw a correlation between this piece of evidence and the person that we're accusing of the crime. So understand those two types of evidence as we get into this. And then really just the final thing is the verdict. Again, very controversial. Our Constitution is built upon the back of this idea of a jury. And the jury in the end, doesn't matter what the cops say, doesn't matter what the judge says, doesn't matter what the attorneys say, the jury in the end is going to decide whether or not that person's guilty. So again, you can hate it all you want. This is the way the system is. The jury will decide that. Many, many cases have frustrated attorneys and the public when they watch going, how did that person get off of this particular crime? In the end, the verdict is up to the jury and they get to decide. That's the system that we have. This is the court system pretty quickly. There's a lot of stuff to this. I could teach an entire course, and I do. But for this 1010 class, just understand how we have gotten to this point. There's a lot of things in the court system that we could change. So as we start to talk about, doing things to change policing, clearly there are a lot of things we can change in the courts. And as we go into next chapter, I'm going to tell you that some of the main things that we could change to affect all the bad things that are happening is really in corrections and the way that judges make decisions in sentencing. So I'm going to tell you right now, I'm going to kind of prepare you for this. As much as we get focused on the reforms of policing, there's just as many, if not more, reforms that have to happen in the courts. We have done a lot of things for 50 years with our correctional facilities and how many people we incarcerate and how we do that and who gets punished and who doesn't. There's a lot of things that need to be changed there, and we'll get into that as we talk about that in the next chapter. However, focus on the courts. I'll be putting your test online again this weekend like I always do. This will be test number 3. Your final test will be about corrections, and then remember, it's comprehensive. I'll throw in a few other questions, but I'll do a video that does a good review for that final later on. So start getting your work put in. Most of you have done a good job. You've got it all put in. Make up what you can, and be prepared Friday to see the test on the courts.